turning to the last section of the rules, judicial conduct. Judicial conduct makes up 2 to 8% of your total MPRE examination. So one thing I want to point out before we dive into a few rules, a lot of people have asked me in the past when they're preparing for the MPRE if this is a section of the rules that they can skip because it's so infrequently tested. And my answer is always no. All of these rules are fair game. And even though the rules regarding judicial conduct are not super heavily tested, they're still tested. And you might as well put yourself in the best position possible to get as many points as possible. Now, knowing the frequency in which these topics are tested, it's very helpful to guide you in how you prepare, specifically in how you use your time. So, would this be the first section to devote a ton of time and attention to? No. Conflicts of interest is the most highly tested topic. And if you were short on time, I would tell you to start there. So again, don't skip any topic, just use your time accordingly. So if you remember back to a few videos ago, we compared lawyers, prosecutors, and judges to one another from an ethical responsibility perspective. Now that we're talking about judges, I think it makes sense to revisit that. I like to think of this comparison in the context of a ladder. I think of us normal lawyers on the lower rung of a ladder. The next, a higher up rung with more responsibility, are prosecutors and government lawyers. Then yet again above them, even higher up on the ladder with even more of an ethical responsibility, are judges. With that in mind, let's talk about disability and impairment. The rule says that a judge having a reasonable belief that the performance of a lawyer or another judge is impaired by drugs or alcohol or by a mental, emotional, or physical condition shall take appropriate action, which may include confidential referral to a lawyer or judicial assistance program. It may also include directly speaking to the person. Thus, this is what I mean by that extra ethical obligation that the rules are placing upon judges. Pursuant to this rule, a judge with a reasonable belief of this information needs to take action. The rule specifically says they shall take action if they have a reasonable belief that a lawyer or a judge's performance is being hindered in some way. Now, it's important to note that the action could differ depending upon the circumstances presented. It could be talking to the person, or it could be going as far as referring them to some sort of substance abuse program. The next rule is all about responding to judicial and lawyer misconduct. I'm hoping this first rule we cover looks very familiar to you because it's one we've actually already covered before. But it's so important, I thought it would be worth briefly discussing again. The rule says a judge having knowledge that another judge or lawyer has committed a violation of the CJC or MRPC that raises a substantial question regarding that judge's or lawyer's honesty, trustworthiness, or fitness as a judge or lawyer in other respects, shall inform the appropriate authority. This rule is identical to the rule regarding reporting misconduct for us regular lawyers. So the same rule applies to judges. They have this obligation to report professional misconduct about lawyers and the judges that they see. So remember that two-part test we previously discussed, because it's equally as applicable here. First, double check that the fact pattern gives you knowledge, because this rule requires knowledge. There is no duty to report misconduct if a lawyer doesn't know that it has occurred. Assuming the fact pattern communicates that the lawyer or judge in question has knowledge, the next thing to ask yourself is what type of rule violation is at issue. Remember, not all rule violations have to be reported. If that were the case, the rule would simply state that. Instead, the only types of rule violations that must be reported are those that raise that substantial question to the lawyer's honesty, trustworthiness, or fitness in other respects. Now remember, we discussed judges having a heightened ethical responsibility. This rule is a good example of that because it goes on to state a judge who receives information indicating a substantial likelihood that a judge or a lawyer has committed a violation of these rules shall take appropriate action. This could be talking to that judge or that lawyer about it, or reporting them to the proper authorities. So here, not only is there this responsibility for a judge to report rule violations that they have knowledge of, that raise that substantial question as to that judge's or lawyer's honesty, trustworthiness, or fitness. But there's an additional requirement that says if a judge comes to know about information that indicates a substantial likelihood that another judge or lawyer has committed a rule violation, then they need to take appropriate action. And again, that appropriate action could differ depending upon the circumstances. For example, a judge is walking through the hallways of a courthouse one day, and this judge overhears two lawyers talking about another lawyer that the judge happens to know. And this other lawyer is identified by name. The two lawyers are talking about how this specific lawyer in question has been showing up frequently drunk and falling asleep and unable to do his job and smelling like alcohol. They discuss how everyone seems to know of this behavior, but no one's really done anything about it. So in this instance, is this a situation where the judge would have an ethical responsibility to do something? And the answer is yes. The fact that the judge overheard this information and the lawyer in question was identified by name, and it's someone that this judge frequently sees, and this information being reported is very specific about specific instances in which this lawyer appears to be drunk at work. This is all enough to raise that substantial likelihood that there might be a rule violation occurring, and therefore the judge needs to take appropriate action. So again, the judge's action could vary from having a face-to-face conversation with the lawyer to taking more serious steps. But nonetheless, there is this requirement for the judge to act. The next rule on this topic that we'll cover is about cooperating with disciplinary authorities. The rule says that a judge shall cooperate and be candid and honest with the judicial and lawyer disciplinary agencies. A judge shall not retaliate directly or indirectly against a person known or suspected to have assisted or cooperated with an investigation of a judge or a lawyer. Remember, we are a self-reporting profession. We have to report other lawyers when they violate the rules. Thus, our job with respect to these reporting requirements is therefore to cooperate with an investigation that might result. So here a judge has just that, an obligation. They can't take steps to hold an investigation against someone, or if they find out that someone helped aid in an investigation, they can't hold that against the person that helped. The judge has to be neutral and understand that this is part of the job. The next rule that we are going to discuss is disqualification. The general rule says that a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. So I want to stop there before we dive into these enumerated circumstances. This is saying that the list that we're about to cover is not exhaustive. There are circumstances in which we know a judge's impartiality would be questioned, and those are on this list, but it's not exhaustive. In other words, there are plenty of circumstances that are not captured by this list. But from an exam perspective, being familiar with this list is helpful. So turning to the rule, it says, the judge shall disqualify himself or herself if the judge has personal bias or prejudice concerning a party or a party's lawyer, or his personal knowledge of the facts that are in dispute in a proceeding. This makes sense because a judge should be impartial and neutral. The rule states, if the judge knows that the judge, their spouse, or their domestic partner or person within a third degree of relationship to them, or their spouse or their domestic partner is a party in the proceeding, or some sort of officer, director, general partner, a trustee, or managing member of a party, or if they're acting as a lawyer in the proceeding, or a person has more than a de minimis interest that could be substantially affected by the proceeding, or is likely to be a material witness in that proceeding. So to stop there, this is not a situation where the judge directly has an interest, because obviously that's very problematic. They would need to disqualify themselves. But if anyone the judge could be affected by, like their partner or their spouse or a family member, if those people have an interest in a proceeding, or is a lawyer in the proceeding, or is a party to a proceeding, or a witness in that proceeding, those are all situations where the judge's impartiality would be questioned. and thus the judge needs to disqualify themselves from that action. The next portion of the rule says, when the judge knows that he or she, individually or as a fiduciary, or the judge's spouse, domestic partner, parent, child, or any other member of the judge's family residing in the judge's household has an economic interest in the subject matter, in that controversy, or in the proceeding. So again, this is expansive. It's not just the judge who might have an economic interest that would lead to disqualification. It's anyone in the judge's house. If they have an economic interest, then it's definitely grounds where the judge would be deemed interested and needs to disqualify himself or herself. The next set of circumstances states that when the judge knows or learns by means of a timely motion that a party's lawyer, or a law firm of the party's lawyer, has within the previous years made a certain number of contributions to the judge's campaign. This is a scenario where the judge knows who his or her main contributors are, or people who have contributed a lot in the past. And if there's an instance where these people come before the judge would need to then disqualify himself or herself. Or if the judge is made aware of this information, then the judge must take steps to disqualify themselves. The rule goes on to say that if the judge, while serving as a judge or a judicial candidate, has made a public statement other than in a court proceeding, judicial decision, or opinion that commits or appears to commit the judge to a particular result or to rule in a particular way in the proceeding or controversy. So if the judge has made a particular statement promising to do something or promising to rule a certain way under certain circumstances, and then such circumstances or a particular case comes before the judge should disqualify themselves. Similarly, if the judge did any of the following, they need to disqualify themselves. If they served as a lawyer in the matter or in the controversy, or if they were in fact associated with a lawyer who participated substantially as a lawyer in the matter during that association. So to stop there, if the judge worked at a law firm before taking the bench, and one of the lawyers at his firm was working on a case, even if the judge didn't personally work on it, we just assume the judge might have information that would be problematic. Thus, if this case comes in front of the judge, he needs to disqualify himself. Or if the judge served in governmental employment and in such a capacity participated personally and substantially as a lawyer or a public official concerning the proceeding, or has publicly expressed in such a capacity an opinion concerning the merits of the particular matter in the controversy. In this instance, it's kind of the exact same thing I said in the private sector, but now just government. So while in the previous role, if the judge worked for the government prior to taking the bench and they had been involved in the matter, they need to make sure that they're disqualifying themselves if this matter comes in front of them, or if the judge is a material witness in the matter or previously presided as the judge over the matter in another court. They need to disqualify themselves. Remember, this list is not exhaustive, but instead, it's just some circumstances in which we know the judge's impartiality would be questioned, and therefore disqualification would follow. But it's not the only instances of disqualification. So on that note, judges have an obligation to keep informed about their own personal and their fiduciary economic interests. And they have to make a reasonable effort to keep abreast and informed of this information, not only about their own personal interest, but as well as the interests of the people in their household, like their kids, or their spouse, or their domestic partner. So this is placing an obligation on them to stay informed so they can understand their interests and disqualify themselves when necessary. Turning to the idea of disclosure, a judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes that there is not a basis for disqualification. Therefore, if the judge thinks that there is any reason someone might think he or she can't handle the case or shouldn't hear the case, the judge needs to put that information on the record and let the parties decide how they feel. This is true even if the judge believes that they can do their job and that they can be impartial. That's okay. But if there's still information out there that the judge has, and If he were in the lawyer's shoes or the party's shoes, he'd want to know. Then that's the type of thing that should be placed on the record. Now, let's talk about waiver. Judges subject to disqualification under this rule, other than for reasons like bias or prejudice, may disclose on the record the basis for their disqualification and may ask the parties and their lawyers to consider, outside of the presence of the judge and outside of the presence of the court personnel, whether they would waive the disqualification. And if following this disclosure, the parties and the lawyer agree, without the judge and without the court personnel, that the judge shouldn't be disqualified, then the judge can move forward and participate in the proceeding. Now, this agreement reached needs to be incorporated on the record. So I just want to stop there. This is a situation where the judge puts on the record the basis for disqualification. But the judge tells the parties that this is information you need to know that could technically disqualify me, but I don't think I should be disqualified. Then the judge tells them to take a recess to discuss amongst themselves in private what they think and feel about that information, and then to come back together on the record to report their decision to the judge. The parties might want to disqualify the judge. They might be concerned, and they have a right to make that decision. Or they might come back and say, we're really not concerned at all, and we want to move forward. And then that gets put on the record, and then the judge can move forward and hear that case. Therefore, remember that the judge has to let the parties decide this outside of the court's presence. It's not something that the judge can put them on the spot and force them to decide on the spot. If so, that would violate this rule. Let's turn to a quick example of waiver before we move on. A judge is hearing a case between a plaintiff and a defendant. The plaintiff happens to be the judge's second cousin. The defendant is being represented by a lawyer that is currently married to the judge's college ex-girlfriend. The judge is annoyed that this defense attorney is married to his ex-college sweetheart. He always thought that his ex-girlfriend should have married him instead of this defense attorney. The judge decides, however, even though he's biased against this guy, he's going to be open-minded and wants to hear the case anyways. He puts on the record information about his relationship with the plaintiff and asks the parties to waive his disqualification. He allows the parties to talk in private, out of the courtroom and out of the presence of the judge and court personnel, whether to waive this disqualification. Ultimately, the question I pose to you is what the judge did ethical, or did the judge violate these rules? And the answer is, under these facts, the judge cannot ask for a waiver of disqualification because I told you that he specifically feels biased against the defense attorney. And remember, you cannot ask for a waiver if you are biased or prejudiced. The rule specifically says you can ask for a waiver of disqualification for basically everything other than bias and prejudice. The next part of the rule says that a judge's obligation to not hear or decide a matter in which disqualification is required applies regardless of whether or not a motion for disqualification is filed. So this means that a judge shall not wait for a party to file a motion for disqualification to bring relevant information regarding disqualification to the parties. If a judge knows that they have information, then they need to put that information, those reasons for disqualification, on the record, even if the parties have not yet filed a motion. This is the judge's responsibility. Getting to the next issue of necessity. The rule of necessity may override a rule of disqualification. This means if there's ever an instance in your fact pattern when there's not another judge available and there's a very time-sensitive matter, even if the judge in question is otherwise supposed to be disqualified, we would allow this necessity to overrule or override that issue of disqualification, so that an otherwise ordinarily disqualified judge could make that very time-sensitive decision since no one else is available. But that's it. Then the judge would have to hand off that case to someone else who's better equipped and better qualified to handle it. So just know that sometimes the rule of necessity might have to override disqualification. But usually, again, those reasons are because it's time sensitive and no one else can handle it based upon the sensitivity of time in which it's presented. The next rule we're going to discuss is extrajudicial activities. The general rule is a judge may engage in extrajudicial activities. However, when engaging in these activities, a judge may not do certain things. So let's talk about these things in which they can't do. The first is they're not allowed to participate in activities that will interfere with the proper performance of their judicial duties. So, stopping here, this means first things first, a judge is a judge. This is their first and their main job. So, they need to make sure they're capable and able to do that before they start engaging in other activities. If these other activities are getting in the way of a judge being able to do their job, then they can't do those extra activities. Next, participate in activities that will lead to frequent disqualification of the judge. And as I just mentioned, being a judge comes first. So if engaging in certain activities causes the judge to have to disqualify themselves frequently, that means they can't do their job. If they can't do their job, that's problematic. So they shouldn't be engaging in those extrajudicial activities. Next, participate in activities that would appear to a reasonable person to undermine the judge's independence, integrity, or impartiality. So if you see a fact pattern where a judge is participating in a group that has discriminatory practices, the judge is not supposed to have any sort of association with that group, because then we'll associate the judge with them. And those people clearly discriminate or have their own issues that would call into question that judge's independence, integrity, and impartiality. Judges engaging in conduct that would appear to a reasonable person to be coercive. The example in the outline states that depending upon the circumstances, a judge's solicitation of contributions or memberships for an organization, even as permitted by the CJC, might create the risk that the person solicited would feel obligated to respond favorably or would do so to curry favor with the judge. Additionally, making use of court premises, staff, stationery, equipment, or other resources, except for incidental use of activities that concern the law, the legal system, or the administration of justice, or unless they're otherwise permitted by law. So this means while they're allowed to participate in extrajudicial activities, they shouldn't be using court resources to do so, unless it's for an incidental use for something that's specific to the law, the legal system, or the administration of justice. The next rule that I want to discuss is about a judge's participation in things like educational, religious, charitable, fraternal, or civic organizations and activities. The rule says that judges can participate in activities sponsored by organizations or governmental entities concerned with things like the law, the legal system, or the administration of justice, and those sponsored by educational, religious, charitable, fraternal, or civic organizations that are conducted for profit, including but not limited to the following activities. So again, to stop here, this is another reminder that these are all things a judge can do, but it's not exhaustive. So just because something is not on here doesn't mean that they can't necessarily do it. The rule states that they're allowed to assist the organization or the entity in planning related to fundraising, so they can help them make plans to raise funds. They can solicit contributions for these organizations or entities, but only from certain people, specifically members of their family or from other judges over which they do not have supervisory or appellate authority over. Remember, judges can't be seen to be acting coercive, and we don't want them pressuring people into giving them money. Thus, we want to make sure that anyone they're soliciting funds from are normal people in the judge's everyday life that they really don't have any sort of special power over. They're allowed to solicit membership for these organizations or entities, but only if this organization or entity is concerning the law, the legal system, or the administration of justice. I'll point out that you should notice a theme here. These entities that are concerned with the law or the legal system or the administration of justice are given preferential treatment under these rules. Appearing at or speaking at, receiving an award or another type of recognition, or being featured in the program of, and permitting their title to be used in connection with an event of an organization or entity. But if this event is serving some sort of fundraising purpose, then the judge can participate only if those events concern the law, the legal system, or the administration of justice. So stopping there, you can see that the law, the legal system, or the administration of justice pop up again. So judges are allowed to participate in these events and speak at or get an award or have their title used in these fundraising events, only if it's an event concerning the law, the legal system, or the administration of justice. If they're participating in a different organization event that does have a fundraising purpose, then they can't do things like speak at, appear, receive an award, use their title, and the like. We generally do not want the judge fundraising. Making recommendations to such a public or private fund, granting organization or entity in connection with its programs and activities, but only if that organization is concerned with the law, the legal system, or the administration of justice. Serving as an officer or a director, a trustee, or a non legal advisor of such an organization or entity, unless the organization or entity will be engaged in proceedings that would ordinarily come before the judge or will frequently appear in the courtroom which the judge sits or is under their appellate jurisdiction, because this would lead to a situation where they would have to frequently disqualify themselves. And remember, a judge's obligation is first to be a judge. They're not supposed to be doing things off the bench that impedes their ability to do their job. So if participating in this manner would lead to frequent disqualification, then they cannot do it. The next thing I want to discuss is compensation with respect to these extrajudicial activities. The general rule is that a judge may accept reasonable compensation for extrajudicial activities permitted by these rules or other law, unless such an acceptance would appear to a reasonable person to undermine the judge's independence, integrity, or impartiality. So stopping there, you'll notice that this rule does not provide us with a specific dollar amount that's applicable. Instead, the rule states that a judge should never accept anything that would call into question their independence, integrity, or impartiality. So just keep that in mind. There's not this hard and fast dollar amount that you must memorize. You have to assess the facts and the circumstances to make such a determination. The next rule that I want to discuss is about reimbursement of expenses and waivers or fees or charges. The rule says, unless otherwise prohibited by these rules or another law, a judge may accept reimbursement of necessary and reasonable expenses for travel, food, lodging, or their incidental expenses, or a waiver or a partial waiver of fees or charges for things like registration, tuition, and the like, from sources other than the judge's employing entity, if those expenses or charges are associated with the judge's participation in extrajudicial activities permitted by these rules. So stopping there, assuming that the judge is participating in something that they're allowed to participate in ethically, then they too can receive waivers for fees or partial waivers for fees or reimbursement for expenses that they've incurred as a result of their participation. So to be clear, if they can't participate by virtue of the rules, then they also cannot accept reimbursement or a waiver of fees with respect to that activity. Now, the next part of this rule, though, goes on to tell us that reimbursement of expenses for things like necessary travel or food or lodging or those other incidental expenses need to be limited to the actual costs reasonably incurred by the judge, and when appropriate and on occasion, to the judge's spouse, domestic partner, or their guest. So again, to stop there, this means if the judge is being reimbursed for their own flight or lodging or food, and they've been allowed to bring their husband or a guest, and this group wants to reimburse the judge for the guest's fees, then the judge can accept that. They can accept reimbursement for their spouse or their guest as well. Now, a judge must assure himself or herself that acceptance of reimbursement of fees or waivers will not appear to a reasonable person to undermine the judge's independence, integrity, or impartiality. And there are some factors that a judge can consider when deciding whether or not to accept reimbursement of fees or a waiver of fees for attending a particular activity. So before we talk about those factors, there's not a hard and fast dollar amount that you must memorize. There is not a certain threshold in which the judge can or cannot accept. Instead, the judge needs to make the assessment of whether or not accepting this type of reimbursement or waiver would call into question by a reasonable person their independence, integrity, or impartiality. And remember that this is a list of factors, meaning none of these are necessarily dispositive. And similarly, this is not exhaustive. These are just things that the judge should consider when making this decision. Now, I'm not going to read all of them on the list, but there are just a few that I'm going to point out. The first is whether the sponsor is an accredited educational institution or a bar association, rather than a trade organization or a for-profit entity. Whether the funding comes largely from numerous contributors rather than from a single entity. and is earmarked for programs with specific content. Whether the activity is primarily educational rather than recreational, and whether the costs of the event are reasonable and comparable to those associated with similar events sponsored by the judiciary, bar associations, or similar groups, and whether information concerning the activity and its funding are available upon inquiry. Lastly, keep in mind that when a judge accepts reimbursement of expenses or waivers or a partial waiver of fees on behalf of themselves or their spouse, domestic partner, or guest, they have to publicly report these types of things pursuant to these rules. And there are reporting requirements in the rules. So this is just a nice reminder that acceptance of these things would trigger the reporting requirement. So that wraps up our discussion of the rules regarding judicial conduct.